to continue and he did not say anything. That's why I was asking you, appearing together with him, I just wanted to hear from him. Yes.
Your Worship, let me apologize that I didn't have the opportunity to introduce myself. Clearly, the prosecution was still busy.
Yes.
So, Advocate Philip Dlamini, and I've been instructed by the court's attorneys.
You've been on record on previous occasions.
Yes.
Okay. Then yes,
And
no
my colleague,
issues.
I think he's around, Your Worship. He has not run away.
Yes.
Unfortunately, when we were called in, I couldn't see him, so I had to rush.
No, it's fine. As long as you are both here, the matter can proceed. Thank you.
This is Your Worship states submit as follows. The state has been approached by the mother, by one of the complainants, Your Worship here, Mrs. Margaret Masiolo, Margaret Malaza. Your Worship, in particular, Your Worship, accused number one, Your Worship, when he was released on bail on the 12th of September, Your Worship, one of the bail conditions, Your Worship, was that not to have direct or indirect contact with the complainants. That even went as far as social media, Your Worship, DMs, Twitter, all platforms of social media. And further, Your Worship, we was prohibited from entering the primary school in question, Your Worship, where the incident transpired, Your Worship. And according to the complainant, Your Worship, on the following dates: 12th September 2024, 18th September 2024, 20th of September 2024, 23rd of September 2024, 26th of September 2024, and on the 6th of October 2024, the accused, Your Worship, Paseka Mutshwane, had been briefing with different, Your Worship, media podcasts, where he made some statements, Your Worship, accusing Miss Margaret Masiolo Margaret Malaza, Your Worship, as a person who set alight to his church. And Your Worship, according to Mrs. Malaza, Your Worship, on those podcasts, he bragged, accused number one, about owning many firearms. And that because of that, Your Worship, she feels threatened and that she lives in fear. And Your Worship, she also indicated to the state that even at the mall, she can't now walk freely because there are people that are threatening her because of the allegations against her that he set alight to the church, Your Worship. State requests that, Your Worship, the court warn the accused number one in particular, Your Worship, that when he attends media briefings, podcasts, whatever modes of communications, Your Worship, that he must refrain from making a reference to Mrs. Masiolo Margaret Malaza, Your Worship. God please us.
I just want to understand that the nature of the application that is now brought as to it's brought as an amendment to the conditions. What is it? I'm struggling to understand because you are talking about bail conditions. Now you are talking about something that is unrelated to the bail conditions themselves.
Your Worship, the bail conditions, Your Worship, was that not to contact the complainant, but Your Worship.
Did he contact the complainant?
That, Your Worship, included the social media. But because of the allegations that were made on social media, Your Worship, those then did not sit well with the complainant. Hence, Your Worship, she has indicated that she does not feel at ease, Your Worship, and she does not feel safe as a result.
way. I just want to understand it quite clearly as to whether or not it has a direct bearing on the matter or not, because her safety, according to her, is compromised.
Correct, Your Worship.
Did the accused, number one, incite people to go and attack her or to harm her in any way, or he just made reference of her as the person who could possibly be responsible?
She made reference.
He only made reference.
Correct, Your Worship, yes.
Let me hear the defense.
Court pleases.
That's the complaint. Your Worship, this is a new application. If I'm not wrong, Your Worship, the prosecution is trying to amend the bail conditions. Your Worship, we do not have a charge sheet. No, we were informed of the names of witnesses. If the prosecution is trying to amend the bail conditions and is now informing us that Ms. Malaza will be a witness, it's a new thing. Your Worship,
Did she say it's Malaza? I thought I had a different surname.
perhaps I made a mistake, Your Worship.
I had Siolo, not necessarily Malaza, but the prosecutor can clarify.
Court pleases. It's Masiolo Margaret Malaza, Your Worship. Same as Malaza.
Thank you. Thank you.
Yes, you may proceed.
Your Worship, it is public knowledge that the incredible happening church was burned down. And the leader of the church will have to address the media about the church. Your Worship, I believe that the allegation has no substance because there is no breach of bail conditions. Thank you, Your Worship.
Your right to reply, ma'am.
Your Worship, state stands by the submissions, Your Worship, that in the podcast, the name of the complainant, Your Worship, should not be mentioned, Your Worship, in any social media platform, Your Worship, by accused member.
She is complainant on which count?
May I just, for the judge,
Yes.
Your Worship, quickly? Mrs. Malaza, Your Worship, is the grandmother
Yes.
to the minor children that were kidnapped, Your Worship.
But is she then a complainant in the matter? Because you said
Oh,
He must refrain from mentioning the name of the complainant.
Oh,
I'm
wrong.
asking, on which count is she a complainant?
court please, Your Worship, wrong choice of words, Your Worship. She is a grandmother to the minor children that
Yes.
were kidnapped, Your Worship, yes.
And that makes her what?
A guardian, Your Worship.
Because I may be wrong. By virtue of being a grandmother, it doesn't automatically make one a guardian. It could be that if the minor children still have either a father or a mother, the mother or the father could be the guardian, unless otherwise the circumstances are different. But you would have to address me on that aspect for me to satisfy myself whether or not she can be classified as a guardian or not.
Court please, Your Worship,
Yes.
just a minute. Court please, Your Worship, she is the grandmothership to the minor children. Number 2, she is also a witness, Your Worship, and has made a statement in the docket, Your Worship, as per 18, Your Worship.
Just a second, there's something that I'm looking for here. Yes, sir.
Can I ask permission for
Yes.
this particular issue of guardian?
Yes, you may proceed.
Your Worship, desperate action trying to make sure that the first accused is kept in prison unlawfully. It's painful, Your Worship, when the court has already made a decision whose children are they. Personally, Your Worship, I've been before the children's court in the same premises or in the same area but in another court.
Yes.
Your Worship, there is a court order dated 18 September 2024. Just to put it on record, Your Worship, it's an interim order
Yes.
filed 2014/4-282/2024. Magistrate Court, Judiciary, Republic of South Africa. Name of children. Your Worship, I won't read the name of children because there is media inside here.
Yes.
Order. The minor children being number 1, remain in care of biological father, Revival Motsweni. Accused number 3. 2, the minor child, number 2, remain in care of the maternal grandmother, Margaret Malaza. And the court order is very clear. Number 3, the minor child, number 3, number 2, to have contact with her siblings and the social worker, Ms. Sibia, to facilitate such contact. Your Worship, I made a mistake when I read the first order. Let me correct myself. The minor children, there are 3, Your Worship, are to remain in the care of their biological father, Revival. There are 3, Your Worship. Even the child that had remained with their maternal grandmother was given over to his father. Your Worship, as I pointed out, that their father, accused number 3, is the correct word, is the responsible parent with all the rights provided by the law, specifically Section 21 of the Children's Act. The grandfather automatically has those rights to those children. In fact, this country's court have ruled that if the children, the father of the children cannot maintain the children, their paternal grandparent tend to be responsible for that. So
my apologies, sir. I don't mean to cut you off, but I am of the view that the submissions are no longer addressing the issue before me. They are now addressing other issues. So the fact is, the state is alleging that there were bail conditions put in place by the court indicating that applicant number 1, which is accused number 1 in this instance, must not in any way, using media or any other form, mention any of the witnesses. But upon reading the record on the 12th of September, it states in simple terms, you accused number 1, it says here, accused number 1, you are to have no contact with the state witnesses in this matter. You are prohibited from entering the said primary school where the incident transpired. You are warned to appear in court. It doesn't say anything about social media. It doesn't say anything about contact. I just want us to limit ourselves to the application they are making for additional measures to be put in place to try and protect the victim in question. But at the back of my mind, the question is, if, for instance, I make an order that says he must not mention her in any podcast, how is it relative to the safety in question? Because what is done is currently done. She is fearing for her life, according to her, even though there is no formal evidence placed before me, it's just submissions. If I were to make such a condition, are you of the opinion that it would assist or not?
Your Worship, that's completely unfair to the first accused.
Yes.
Your Worship, I have already drawn your attention that as the state was alleging that he has a parental right, and correctly, Your Worship, you asked, how do they get those parental rights? Now, I have already demonstrated, Your Worship, that there is no such right. Your Worship, when it comes to the issue, anybody can allege anything. There is no threat, there is nothing that is bail condition that has been contravened by the accused. Your Worship, in this situation, Your Worship, it makes it even very difficult for one to think how could this particular situation help, Your Worship. Your Worship, can I approach?
Yes.
Thank you.
It's a Mboro. And actually, I spoke of the suspects on my case. Mrs. Malas is a suspect on my case. And the church was banned for her. No, it didn't listen. The church was banned because Mrs. Malas had to take it out of the court. They wanted it out of the court.
Thank you, Your Worship.
Yes.
The Worship, the state has not really put a situation where it can show that the accused are a danger to the complainant, Ms. Malaza. In fact, Your Worship, it's just a complaint that does not belong to this court. It's a complaint that she talks about something that addressing the issue of another case where accused number one is a complainant and she's a suspect. So it does not belong to this particular court, and it should be addressed at the court where it belongs. In this case, I understand the prosecutor is trying to bring in issues that are of concern but have no substance. That's my position.
I just want to understand the conduct of the accused. Is it endangering the safety of the witness by merely probably stating her name? Yes, you have indicated that there is a case open or existing where probably Mr. Mutwening could be the complainant and the said witness could be the respondent. But the conduct in itself, would you say that it endangers the safety of the said witness or not?
Your Worship, openly, when you're dealing with addressing journalists, they deal with issues of public interest. They do not endanger anybody. Now, journalists are responsible people. They will never put in issues that endanger someone. And in this situation, Your Worship, the state is referring to professional people who have understand the principle of journalism at its best. Now, there is nothing that endangers the life of the complainant. Your Worship, I can safely say to you that since the beginning of this issue, the accused have behaved properly. They address journalists as the journalists request to be addressed by them, and they cannot hide certain things that journalists in the public interest want to know. And in that situation, Your Worship, if we curtail that, we will be going against freedom of speech and the freedom of press. The press has a responsibility to report to its readers or listeners, and the case of a radio or TV audience. So those are acting responsible, Your Worship. And if there is something wrong, we've got the press ombuds to complain to. Your Worship, it has been brought to my attention that the accused is even surprised that he ever mentioned Malaza. Yes, he may have talked about Moho, which it may mean to the same person, but the issue of Malaza, Your Worship, the accused is surprised that he has ever mentioned that.
So in other words, the identity of the said person was not described. It can only be an inference that is drawn that when a particular name is mentioned, it therefore relates to the said person.
Yes. Your Worship, this whole dispute, as we stand here, it is a dispute between family members. I don't mean to also stop you at this stage, but I feel like you are now venturing into a direction that will not necessarily assist us. Yes. As the court places. That's the situation, Your Worship, before you. There is no threat to the complainant. And the only issue is that they want to extend the bail conditions. And Your Worship, they have to give a very good ground for that extension. As for now, there is none, Your Worship. Thank you.
Thank you, Miss. From the state, any submission after what they had indicated? They indicated that Mr. Mutwening is a complainant in a matter that relates to the burning of the church. Is he prohibited as a complainant to can discuss matters relating to that particular case, since that case is not before me?
Your Worship, State Your Worship here is talking about a witness, Your Worship. This
Yes.
Ms. Malaza, Your Worship, has indicated is a witness, Your Worship.
Okay.
And if one, Your Worship, looks at section 64C, Your Worship, where
Yes.
it stated that I will not attempt to influence, intimidate witnesses, nor
Yes.
will I conceal or destroy evidence. Your Worship, she is indicated, Your Worship, after consultation that she feels threatened, Your Worship, because of what she has heard, Your Worship. And based on that section, Your Worship, 16.4c, Your Worship, which makes part of his application when he made before court, Your Worship, to be
Yes.
admitted to bail, she feels threatened, as she had informed me, Your Worship, that she's mentioned.
So the application is made on the basis of section 60, subsection 4, paragraph C.
Yes, and at this stage, Your Worship, the court really was not even applying that the bail be cancelled, Your Worship.
Yes.
It was merely asking this court that he refrain
Okay.
from mentioning,
Okay.
because mentioning of her name makes her feel
Okay.
threatened, Your Worship.
According to the information that you have, she was mentioned specifically as Maggie Margaret Malaza, or what is the situation? Because I don't have the information at my disposal. Do you have an affidavit from
I
her?
have an affidavit,
Okay.
permission to read it into the record, Your Worship.
Yes.
Court cases. Katlehong case number 76/08 of 2024. Masiolo Margaret Malaza, state under oath in English. I'm an adult African female with ID number 680201063783, residing at it's her
No,
address, Your Worship.
you don't have to mention the
The
address.
address
You
and
can
the
keep
cellular
the
phone.
addresses.
Thank you, Your Worship. I am a witness on Katlehong case number 76/08 of 2024. The accused on the matter is Pasaka Motsweni, Pastor Mboro. The above mentioned accused was released on bail on the 12th of September 2024. The accused was given the following bail conditions by the court. 4.1. You have no contact, direct or indirect. You don't send, you don't Twitter, you don't DM, you don't contact witnesses from this case from count 1 up until count 12. You are prohibited from entering the school on. You are prohibited from entering at the school, the primary school where the incident transpired. On the following dates, the 12th of September 2024, 18th of September 2024, 20th of September 2024, 23rd of September 2024, 26th September 2024, and on the 6th of October 2024, the accused Pastor Mboro had briefing with different media podcasts, and where he makes a statement accusing myself and my family that we set alight his church. He further told the media that he is owning many firearms and that everybody knows that that statement alone threatened me and my family. We live in fear. When we walk at the mall, the people are threatening us, saying that we burned their church to ashes. I don't feel comfortable with Pastor Mboro mentioning my name and that of my family on social media. Your Worship, the statement has been signed
Yes.
by the deponent and so commissioned. Your Worship.
Okay. So what was the name that was mentioned in this broadcast?
Court, please, Your Worship. My complainant is before Court, Your Worship, Mrs.
Yes.
Malaza. Can I call him perhaps, Your Worship?
You can call. Let's verify the facts.
Oh, Your Worship, I'm informed that only the sister is here now, Your Worship.
Yes.
The sister who also forms part of the family that feel threatened, Your Worship, as they walk.
Where is the investigating officer?
He's present, he's here, Your Worship.
When you consult with the investigating officer, did he verify the facts as the investigating officer to try and find out whether what the complainant is referring to is actually the truth, or it's just the fact that is mentioned? I'm addressing the prosecutor. You can consult with the investigating officer. But did he do that?
Mrs. Worship, seeing that it's tea break,
Yes.
can we just adjourn for tea, Worship, so that he can dot down all the, as per the dates, Worship, the name of the podcast and all of that?
Okay. I am not asking for the name of the podcast. What I'm asking for is the complainant alleges that a name was mentioned in these platforms.
Yes, Worship.
What name exactly was mentioned in any of the podcasts? And did the investigating officer verify those facts himself to satisfy himself? Yes. I believe because it's tea time, we can adjourn for tea. We will come back at 12:30.
God bless us, Worship.
To the application that is brought before me, the prosecutor informed the court that the application is brought in terms of Section 60, subsection 4, paragraph C. Section 60, subsection 4, paragraph C talks about something completely different, and Section 60, subsection 4, paragraph C would have to be read together with subsection 8. And in this instance, any amendment to bail applications or the conditions thereof must be done in terms of Section 63, subsection 1, which says that the application can be brought either by the state or by the prosecution. It could either relate to the reduction of the bail amount, or it could also relate to the conditions of bail. At this particular stage, the issue that the state is alleging is that by mere mentioning of a particular name on some of the platforms that the accused number 1 appeared on, it automatically makes her fear for her life, and that there are other people who had, since the incident, approached her and threatened her. But in the mind of the court, it's logical to say that where allegations are made, whoever alleges a particular fact must be able to prove. Where those threats were made, are there cases that were opened against the particular perpetrators who were threatening the said witness? Does she even know the identity of the persons in question? This incident of her being approached by unknown persons, does the court have sufficient information to say this incident happened on this day, on this day, on this day, on this day? The only thing that the court was given at this stage was the dates of the alleged mentioning of the name, but the incidents where she was approached, I don't have any information. She is fearful to go to the mall based on what incident that happened, when, where, on what date, and who was the perpetrator on the date in question, and what are the reasonable steps taken to try and ensure that safety is concerned. Can it then be an inference that could be reasonably be drawn by the court or any other person? And should an inference be drawn, is that an inference going to be the only inference that any other person in the capacity either of the court or any reasonable person drawing such inference, can they then safely say that where a name Miss Malaza or Mrs. Malaza is mentioned, it automatically refers to this particular witness? Is the said Mrs. Malaza the only Mrs. Malaza that has ever existed? And is it necessarily because she has to be associated with applicant number 1 because of this present case, or because of the case against her? According to the defense, the submissions are that the accused person is a complainant in a case relating to the burning of the church, the court would have understood it differently if it were to say that she feels threatened because he, on the podcast, discussed details of this particular matter or any of the issues that are related to this matter. As a result, therefore, she feels fearful or threatened. The mentioning of the firearms, is it a fact that became only known to her from the podcast, or is it an issue that existed prior? During the bail application, was it an issue that was discussed? Is it that he could be in possession of licenses in respect of those firearms? Those are some of the things that, when weighing up this particular issue, the court would have to look into in order to draw an inference. And as I have already indicated, there cannot exist more than one inference to be drawn on the basis of the set of facts. Only one inference must exist at the end of the day. If it pertains to Mrs. Malaza, could an inference be drawn that when the accused is speaking about Ms. Malaza on the podcast, automatically it relates to her? There could possibly be another Ms. Malaza other than the one that is mentioned. Unfortunately, at this particular stage, particularly on count number 2, I can't make out the surname. Maybe the state may be able to assist me. There is Megi Mamusileng Ntsiye. I don't know whether this is Ntsiye. I can't make out the handwriting properly. Please assist on count 2.
Meke Mamuseleng. Webster. It's a Webster.
No, the one underneath.
Meke Mamuseleng Webster.
There is Webster on top. There is another one on count 2. There is another Meke Mamuseleng, but the other, it cannot read Webster. The handwriting cannot be Webster.
It's Webster.
Threatening?
Yes, threatening to injure the said Meke Mamuseleng Webster.
Okay.
Thank you.
What is also not clear to the court at this instance is whether the said witness becomes Malaza by virtue of marriage or by virtue of her being born in the household of Malaza, which therefore culminates to the fact that it becomes difficult for one to can be able to safely draw an inference that will relate. Is a matter of state versus Nzuza. Although it was not a high court type of a decision, it was a regional court decision in Durban, where the court was dealing with almost a similar set of facts, even though it is not a precedent at this instance. The court in that matter indicated that for Section 63(1) applications to be done, conditions or circumstances must have changed that will render the necessity to have the bail conditions amended. So under the circumstances, after having listened to the state and the submissions and the incorrect assumption that the matter is brought under section 64C. I am not convinced that at this stage the court should temper or interfere with the conditions as previously placed by the court, because the inference to be drawn can be more than one inference, that it could be another Mrs. Malaza that burned down the church, as long as there was no mention of either the name or the initial or anything that will bear specific reference to the said person who is a witness in the matter. I am satisfied that there are no violations of the bail conditions at this stage, since it was only indicated that he should not directly contact or indirectly contact the witnesses, and not to say that he should not say anything or mention anything. And should he be doing so, it could as well be that he is expressing his views as a complainant in the matter where he had opened a case, and it cannot safely be that his intention was to try and endanger the safety of the witness in this particular matter, because no reference, according to the state, was made to this matter. The reference was made to the incident of the burning of the church, which is a matter that is not before this court. This court cannot amend bail conditions based on a matter that is happening in another court, and which the court has no facts of and cannot be able to comment under the circumstances. So I am of the view that the bail conditions, as indicated, they are sufficient enough to provide protection to the witnesses. Should there be a violation of the bail conditions, the state is fully aware that section 68 will have to be applied, and his bail will have to be cancelled upon an application brought by the state. But at this stage, I don't have sufficient information that would lead me to draw the only reasonable conclusion to be that by mentioning Mrs. Malaza, then it meant indirect harm to the said witness. That by mentioning the issue of him owning firearms, it automatically means that he wants to harm her, or the intention was to try and harm the witness. I am of the view that based on the facts as presented before me, a conclusion cannot be drawn that the mentioning of the name or the firearm was intended to interfere or to influence or to endanger the safety of the said complainant. And as such, I will not grant the application by the state to amend the bail conditions at this stage.
Court pleases the worship.
The court pleases.
Investigation, the worship is complete. Request the matter to be postponed for additional court date allocation.
Investigations are complete in respect of all the counts.
All the counts, yes.
The proposed date for the
11 November. Advocate.
The 11th of November is a Monday.
It is okay with us, Your Worship.
with regards to the status of the 3 accused, they are all out on bail.
Correct, Your Worship. No, accused 1 and 2 out on bail, accused 3 on warning, Your Worship. Could resist.
Thank you, gentlemen. Your matter is going to be dealt with as follows. The matter is postponed to 11 November 2024 at 8:30 DC2 for regional court date. Accused number 1 and number 2 are out on bail. Bail is extended until then. Failure to appear, warrant of arrest will be issued against you. Your bail monies will be provisionally forfeited to the state, and if you don't appear within 14 days thereafter, your bail monies will be finally forfeited to the state. Accused number 3, you are out on warning. Failure to appear, a warrant of arrest will be issued against you. If a warrant is authorized and you are arrested, you may have to be tried for failure to appear, and if found guilty, you are going to be sentenced to a term of imprisonment with or without an option of a fine. The sentencing only happens if you are found guilty for failure to appear. That is not to try and threaten you, it is to explain to you the possibilities of what is going to happen should you not appear at all in your matter. Do you understand, gentlemen? Thank you.
Yalona ichechiseditswe di 11 November di tlo go tla mo DC2 ka pa se tuseng go rothole date ya lona hore nyo ya lona e tlo tswela pele ka kwa regional court date ka ga tsatsi le feng. So accused number 1 le 2 le tswile ka bail enke. Bail ya lona ya sebeletsa ntse ka tsatsi le. Ha sa tle ka tsatsi le go tlo tswa ngolo la go tshwaro le tšhelete ya lona nka jwa ke news ya bail. Wena accused number 3 o tswile ka warning enke ka gore ba o sope ka bolana. Ha o sa tle ka tsatsi le go tlo tswa ngolo la go wena o tshwaro, and ha o tshwarwa mo go tla ba le trial e nngwe tla tshwarwa go go bana o sa tla le go tlile. And ha o ka thola la ba o thola una le molato o tlo patala fine. Understood?
No, I didn't say he will pay a fine. I said he may be convicted and sentenced to a term of imprisonment with or without an option of a fine.
Okay. How ka thola la re una molato ka gore o ska tla mo o ka tshwarwa hape o tshwarela gore ha wa tla mo lekgotleng. Wa utlwisisa? Understood, Your Worship?
Thank you. You can be excused. You may also be excused if that's the role.